Okay, folks, it's 7 o'clock. We're going to open the public hearing on the Wyden application concerning 74, thank you, Bridge Street. About a building permit that was issued back in February concerning water closets in that building. So first we'll start off with Mr. Gailey to make his presentation, and then Mr. David will follow. And then, pardon me?
Part of the public hearing, yeah.
Well, because they have to know what it's about.
Is it possible to use microphones? We can't hear anything.
We have microphones here. I don't know. That's, they'll have a microphone at the podium. So you'll probably be able to hear them.
No, he's not here to use that.
Hello? Hello? That's going now.
That one.
Nothing like a little technical. Okay, folks, don't block the doorways, please. In the event that we should have to clear the room out, there's an exit there, there's an exit there, and through that back door there where it says no smoke or where it says exit. All right, so Mr. Gailey, you can start your presentation.
Good evening, Mr. Chairman and the zoning board of appeals. My name is Ben Gailey with the law firm J&G Law, representing Brendan and
Bring that mic closer to you, Mr. Gailey.
Yep.
Yes.
representing Brendan and Kathleen Wyden. We'll make a brief presentation. The Wydens also would like to make some comments. I think actually, if you don't mind, I'd like my clients to be able to make their comments before I give a presentation.
Well, this is on for a public hearing, so.
Yes, yeah, they're
this
here.
is just to inform the public what this is about, and then Mr. David will respond to that, and then we're gonna have the public.
My clients are just members of the public. They're the appellants.
Okay,
They're the
true.
applicants before the board. And what they have to say is part of our presentation.
Okay, continue.
Okay, so Kathy.
Oh, okay.
Go ahead.
Oh, I'm sorry.
But please make it brief, please.
It is.
This is-
I know, it's got a lot of pages. That's okay. I am Kathy Wyden, the majority owner of the Narrowsburg Union and the founder of several other small businesses that call the Union their home. My husband and partner Brendan and I are here tonight because we believe in the rule of law and we need to know the answer to this question. Is the town of Tusten committed to the rule of law for everyone? Governments, essential part of every community, have a duty to be law-abiding and fair, independent, and transparent in their enforcement of the law. As governments fulfill these duties, they establish a level playing field on which we can all operate, as well as a means by which we hold both our governments and each other accountable. As governments fulfill these duties, they protect the entire community's properties, businesses, residents, visitors, and first responders. When our governments fail to uphold the rule of law, it affects the community's sense of safety and security and undermines our trust in our government. Based on information and documentation we pulled together and placed before this community, in front of this board, in front of all of you, we've come to the conclusion that the town has failed to abide by its own laws and has failed to act in a fair, independent, and transparent manner. We have stepped up to the plate again to do, in this case, what the town has failed to do, because we're personally committed to these critical elements of a well-functioning and welcoming community, those intangibles of duty, trust, and respect. We believe we speak for all of you when we ask this question of the town: is the town committed to the rule of law for everyone? If the town can so significantly fail in its duties with respect to one matter, then other failures of duty could happen anywhere in town, right next to your house. We believe we have one set of laws in this town. They apply to everyone, not just to some. We hope to have this belief confirmed. We hope to be part of the work needed along with members of the community to put things right again. We will continue our practice of making all of our documentation printed and available at no charge to anyone who would like to be informed. Please stop by at the Union at the Print Pack Shift Store and ask for a free copy. We're in our office at the Union most weekends and would be very happy to meet with anyone who would like to discuss any or all of this. As George Orwell once said, in a time of deceit, telling the truth is a revolutionary act. Thank you.
Folks, don't block the doorways back there, please.
Good evening, zoning board members and residents of the town of Tusten. My name is Brendan Peter Wyden. I appreciate this opportunity to speak to you directly. There's been a lot of chatter on social media, and most of it is either not true or slanted at best. Kathy and I are here to set the record straight, and hopefully with everyone's help, to plot a course for the town to move forward in a positive direction. First of all, I want you to know that our commitment to this town and to all of you is that to make this town a place where everyone feels welcome and appreciated, and property values are always being protected. My wife and I love Narrowsburg and the authentic people that make it special. And let me say one thing to make it perfectly clear. We have no disagreement with our neighboring property owners and business owners. And I'm going to repeat that. We have no disagreement with our neighboring property owners and business owners. I want everyone to know that I am proud to tell you that I am the 4th generation of Wydens to call Narrowsburg home. Our children and grandchildren love it here. And as the 5th and 6th generations of our families' Narrowsburg legacy, they will carry on the long Wyden tradition of doing the right thing. And that's kind of the theme, our theme for tonight. We're saying to the town, you've got to do the right thing. We've got to do the right thing. Narrowsburg has been my second home my whole life, and when Kathy and I purchased the Narrowsburg School 8 years ago, hard to believe it's 8 years, Narrowsburg became my primary residence. I vote Narrowsburg. I'm a resident of Narrowsburg. But this tonight is not about whether you or I became part of this community 1 year ago, or whether our ancestors came here 100 years ago. This is about the laws that we have all agreed to live by. We've raised this issue with you, the zoning board, because there is a serious problem with our town government that needs to be fixed. We are here tonight, not just for ourselves, but we are here for the entire townspeople, everybody. What we are saying will benefit everybody, all of you. This problem needs to be fixed, or what happens to us can happen to you too. Basically, the town has not fulfilled its obligation of fair and equal treatment to all. We need to work together to fix our town government, and we are asking the zoning board to take a lead in this mission. One of the fundamental purposes of government is to have laws, to make sure design professions apply the laws properly, and for the government to communicate and enforce those laws. We are a nation of laws. We're a town of laws. There are just two. I happen to have two codes. Would you grab them for me, please? Just unzip that.
No, not. We're in here?
Yes.
Okay. Yeah.
There are two important laws that we think everybody needs to know about. This is the building code of the state of New York, right? This applies to every building in the state of New York. This is the town zoning code. This is an overlay code. These are just a few of the many codes that apply. These laws provide a foundation for good communities and treat all residents in a fair and unbiased way. Without zoning and building codes, you will have unsafe buildings, dangerous traffic conditions, haphazard development, poorly functioning communities, stifled growth, and in the long term, property values will go down. But a code is just print on a page. It needs to be communicated to all parties accurately, applied to each situation and enforced. It is the town's government who has the responsibility to do these things. The root cause of the current tensions is due to the town's government's failure to communicate, apply, and enforce the code and the rulings of the Tusten Planning Board, and failure to communicate to the public the rulings and the code requirements that apply. If you decide to allow some parties to circumvent the codes, you are messaging to future residents and developers that anyone can do whatever they want if they know the right people. If the town government has executed its duties and communicated these requirements with the developers, neighbors, and all town's residents, if they had done this in a timely manner, everyone here would be aware and they would do the right thing. If we allow this dereliction of duty to stand, it will hurt everyone's property value and prevent Narrowsburg from growing into the prosperous, healthy town that we love. This is not a trifle endeavor that we've taken up, and we realize it may not make us popular for people to face the reality of the codes and the law. But I'm fortunate, I have a role model. In my ambition to help the Tusten government take responsibility for upholding, communicating, applying, and enforcing the codes, there's someone who stands out. And that role model is a humble, honest, hardworking man who would not stand silent when the town government and many Tusten residents wanted to sweep a serious problem under the rug. That person is Ed Kraus. I don't know if Ed's here tonight, who he is. I don't know if you know this, many people have come here over the recent years, but in the 1970s, there was a town landfill alongside the Delaware River. The landfill operator accepted numerous drums of industrial.
Mr. White, I'm going to interrupt you now. Now you're going off into something outside of what we're here for tonight.
Okay, fine, I'm just gonna.
Please speed it along. I'm sure we have a lot of people.
Ed is right, my role model. I'd be happy to tell you his story, what little of it I know. He did the right thing. We're doing the right thing. We're doing the right thing for the community. So Kathy and I have taken up this cause with a sincere desire to do the right thing for the town of Tusten and for all of you. So dear zoning board members, please, thank you for listening to us. Let us know how we can help make the town of Tusten operate fair, more efficient, and agreeable for everybody. Thank you.
Folks in the back, there's some empty chairs. If you could fill them in, please, and keep the doorway back there clear.
And you want to.
Right. Okay, Mr. Gailey, go ahead.
Okay, we submitted, well, first of all, the Tusten zoning law prohibits the issuance of a building permit to a building unless the property has received all required approvals and also is in compliance with all applicable laws. That includes not just the zoning law. Your zoning code is very clear that it includes all laws, which then includes the state building code and also the town of Tusten building construction code. So the issuance of the building permit violates the state building construction code. It also violates the zoning law, also violates the town building construction code. So therefore, it violates the town zoning law, and that's what gives the zoning board of appeals the jurisdiction and the authority to hear this appeal. It's the violation of the town zoning laws. It's 3 separate sections in the town zoning laws. It's section 8.1.3, section 10.0, and section 10.1.7. We submitted 10 reasons as to why the issuance of the building permit, backrooms, called water closets in the jargon, is invalid and unlawful. The first one is that there's an unlawful automobile dealer sales business operating on the lower level of that building. And since that's an unlawful use of the building, the issuance of the building permit for that building is unlawful. We've received a response to our appeal from the property owner's attorney on this past Thursday, June 7th. I'll just briefly address some of the comments that were made in that response with respect to our first reason here. They claim in that response that the intention of the property owner was to add a bar to the car dealer premises, and there wasn't an intention to move the auto dealer sales. It doesn't really matter whether there's an intention or not, is what gets approved by the planning board. There's no documentation of any such intention. I'll make a point with respect to the entire response that was submitted on June 7th by the property owner, that there's no documentation or evidence or exhibits or citation to any law or regulation at all. All it is statements. So it's really, you certainly read it, of course. But there's nothing persuasive there. There's absolutely no documentation, no support for any of those statements that are made in that response. It's clear, one of the comments that's made in the response from the property owner is that at all the meetings when the planning board approved the restaurant in that building, that all the planning board minutes are wrong, all the planning board resolutions are wrong. I mean, I don't know what the planning board will think about that. But that was 3 years ago almost, and the property owner had 3 years to to make those corrections. And the property owner was completely content with those minutes and those resolutions until we pointed out in our appeal that they limited the use of the building. And that in fact, the minutes state that the auto sales dealer will be moving to use, quote, Narrowsburg Motors will use the lot on 97, Route 97, near the town highway building to sell their vehicles, because the restaurant was displacing the showroom and the office. So it had to move. Instead, they moved the sales down to the lower level, which is moving a non-conforming use, which violates the town zoning code. That's the violation in reason number 1. Reason number 2. There was a building permit issued for a bathroom on the roof of that building. There's no planning board approval for any use of the roof of the building. Therefore, any use of the roof is unlawful. So a building permit to authorize a bathroom on the roof of the building is unlawful. It can't be issued. I mean, how do you put a bathroom on the roof when there's no use that's been approved for the roof? Reason number 3 is that and the property owner acknowledges this, there's not enough bathrooms on the restaurant level to meet the state building code and to meet the plumbing code. That's the reason they applied for the building permit to put a bathroom on the roof, in the hopes that would give them, additional bathrooms to meet the building code. We pointed out in our reason number 3 that even that doesn't comply with the building code. In addition, they make just the response from the property owner just makes the bare bones statement that the drawings that were submitted to the building inspector, with the building permit application, are drawings that meet the state building code requirements and the town building code requirements. They just make the bare bones statement, they comply. You've seen the drawings in our submission. It's barely a sketch. It's not the construction drawings that are required by the state building code and required by the town of Tusten building construction code. In our appeal, we list all of the requirements for the construction drawings that must be submitted with the building permit application. You'll see for yourself, I'm sure you already have when you went through the appeal, that little sketch that got submitted falls far short of those requirements. Our 4th reason was that the property owner did not demonstrate there was a change in use on the Bridge Street level. And the proposed septic system that they want to install doesn't meet the requirements of the state plumbing code. And again, if it's unlawful under the state plumbing code, that means it's unlawful under the town zoning code, and the building permit cannot be issued. And we set forth in detail in our appeal the requirements of the plumbing code and why the restaurant and the proposed system do not meet those requirements. And again, in the response, there's the response says the town employees went to the site and inspected it, and that's the extent of it. There's no citation to any of the regulations, any of the requirements. And in addition, I mean, it's important that the town employees from the water and sewer department inspect the site. But those plans can only be prepared by a licensed engineer. And that's, again, it's a requirement from in the town code, the town of Tusten code. So although it's good to have the town employees there, that does not meet the requirements of the town zoning law. Reason number 5 was the property owner made site improvements to the site without approvals. The special use permit that was granted did not approve any work outside of the building. But we show with our documentation, photographs that the parking lot was enlarged. The property owner's own survey that was submitted to the planning board shows that the parking lot now, as demonstrated in our photograph, is larger than the parking lot shown on the survey that was submitted to the planning board. We have the photos of the junkyard and the fence to document the damage to the widened fence. Contrary to the statement in the property owner's response that the debris only quote touched the fence. You see the photographs in our appeal. The debris has broken the fence, it's going through the fence, it's heading down the hill on the Wyden's property. We also talk about the retaining wall, which is basically plywood, which the response says is merely intended to keep debris from the site from going onto the Wyden's property. Well, number 1, if that's the purpose, it failed. Number 2, it's not the purpose, it's clear. You visit the site or even look at the photographs, that plywood is a retaining wall. It's holding back the parking lot. If you remove that plywood, the parking lot would erode and fall onto my client's property. And again, there was no work outside approved by the planning board. So that work on the parking lot, enlarging it, is unlawful. It has no approvals. Therefore, building permit issues for that building is unlawful under the zoning law. Our reason number 6 was the property owner had created an unlawful junkyard on the property. We define junkyard in our appeal. It's clear that the debris that's on that property in the parking lot and going through the fence onto my client's property qualifies as a junkyard under the town zoning code definition. And our photographs clearly show that all the debris, and they contradict the unsupported statements in the property owner's response that was submitted to the board a few days ago. Reason number 7 deals with, again, I touched on it already, the unapproved retaining wall, and that our documents demonstrate that the retaining wall is in fact a retaining wall that keeps the parking lot in place and doesn't merely keep debris from my client's property. Reason number 8 is that the New York State Plumbing Code does not permit bathrooms on the unapproved roof. Been through this already. Again, there is no design of any kind that was submitted to the building inspector, and the building permit was issued without any kind of a design. The plumbing code requires that, the state building code requires that design, the town building code requires that design. And again, there's no reference in the response from the property owner to any section of law or regulation or the town code that somehow would support the issuance of that building permit. Reason number 9 was that the internal staircase that connects the restaurant level with the lower level repair shop violates both the New York State liquor authority law, and the New York State Department of Motor Vehicles law. Both of those prohibit a staircase between those two disparate types of uses. The response from the property owner is that the door is locked. It doesn't matter if you read the code, and we cite the provisions in our appeal. The staircase that connects those two different types of uses is prohibited. It's unlawful. Reason number 10 has to do with the signatures on the various plans that were submitted by the architect, allegedly by the architect. The numerous different types of architectural firms, the names of the firms that are identified in the various submissions, both to the planning board and to the building inspector. And out of those 5 or 6 different names, only one of those actually exists. And that's Mr. Woods, the architect, in his personal capacity. and all these other various names that are on the plan that get permitted simply don't exist. That's a violation of the state education law. With respect to that, we have an additional, a supplemental submission to the board. You extra copy I can give to Mr. David.
I'm giving that one.
Do I need one?
Giving that one and here's one for you.
I need one for the board.
Oh, okay. Sorry.
I don't need
two. Okay.
Nope, I don't need it.
Okay.
My, I don't need it.
Sorry.
This is information that my clients obtained just very recently, which is why we weren't able to submit it until this evening. And it supplements what we already submitted. It's not new arguments. It's just additional evidence. Kathy Wyden has spoken to a representative at the state education department who confirms, our statements in our appeal and also in the supplemental statement concerning the names of the various architectural firms, the claims by the applicant on various submissions that Mr. Wasner is an architect and holding himself out as an architect, which is not lawful. And
The ad in the newspaper.
And well, right, and the ad in the newspaper, which says that they're partners, for instance, that as well, that Mr. Woods and Mr. Wasser are partners in the architectural business. That too is unlawful under the state education law. So those plans that get submitted in that way, without being signed by an architect who is licensed in the state of New York, are invalid. And in fact, under the state building code, any permit issue is void in that case. We have one other.
These are cited, never cited like that.
Okay, yeah. These are. This is your own set.
I have another set. Sorry, yeah, here we go.
In our initial appeal.
We can give this to Mr. Sorry.
These aren't new letters. In our initial appeal, we cite these letters, but did not provide copies as exhibits to the appeal. So we're just submitting these now, so in the record of the zoning board of appeals. Again, they're not, they were cited in our appeal. We just didn't provide copies previously. So that's what we're doing now.
Okay, let me see.
That's all I have for now. I'd like to reserve the opportunity to respond to comments made by Mr. David Off or members of the public.
Mr. Davidoff?
Good evening. My name is Michael Davidoff. I represent the owner of the premises, Bar Veloci, the operation that is open and that they created at the place there. You know, once again, the Wyans have appealed to this board here the issuance of a building permit dated February 3rd, 2023. They have, this building permit is a simple document that asks for replacing existing water closet to the basement, add water closet on the first floor to the existing bathroom, and add 2 water closets to the terrace level. The ZBA has authority to entertain appeals when a code enforcement officer, as in this case, issues various permits. But the appeal is limited to the facts of what we are here for. The building permit is limited to the bathrooms. Now, how do we get from the bathrooms to everything else isn't possible? How do you get to the bathrooms to try to close down Narrowsburg Motors that's been operating for 72 years? That's their what they're saying to get along in the community. That's what they're trying to do. This ZBA is limited to the issues that are before it just on this building permit. But the Wydens want you to take everything into consideration. And this is exactly what's happened before. Now, back in 2020, the planning board issued the special use permit after hearing all of the issues. That's when these issues were given the day of light. That's when they had the right to argue before the planning board. And they should have at that time, if they disagreed with the planning board, and what the planning board issued was a special use permit to allow eating and drinking establishment to be known as Bar Veloci on the premises of Narrowsburg Motors. And that was back in 2020. They had the right to appeal then. They did not appeal then. You have a 4-month statute of limitations to appeal to the Supreme Court. They failed to do that. The statute of limitations ran. So what are they doing? There's an end run. Every time the building inspector issues a permit, every time something happens, they put an appeal in an attempt to make it back to what they failed to do in 2020. This happened in October of 2021, when Mr. Crowley issued the certificate of occupancy. And the certificate of occupancy, they attempted to make an end run around at that time, and they started in a Article 78 in the Supreme Court. That matter was heard, and a decision was rendered by Judge Meadow. Judge Meadow saw through their attempt. And what he said was that the substance of the Wyden's appeal concerns issues of on-site parking, access to the parking at the rear, pedestrian access, off-street loading and unloading. All these issues should have been addressed during the hearing on petitioner's special use application. It was during the planning board consideration of our application for special use permit that these issues were raised, and they were decided by the planning board not to be an impediment to granting the special use permit. Judge Meadow, in his decision, found that the appeal of the special use was really an attempt to appeal the special use permit that was issued in 2020, and not the certificate of occupancy. That's exactly what's happening here. The building inspector issues a building permit for 3 bathrooms to be altered. And where are we? We're in appeal again on every single thing that occurred. In essence, this appeal is also an attempt to raise the issues that were before the Town of Tusten Planning Board. Now, first, they claim the reason number 1, change of use of the upper level or additional use of building at 174 Bridge Street. The Wydens are attempting to confuse the issuance of the building permit with a totally unrelated issue. The building permit of February 2nd, 2023 was solely concerned with the bathrooms. The Wydens are attempting to use this to attempt to claim that Narrowsburg Motors cannot operate there. Narrowsburg Motors is not a party to these proceedings. Narrowsburg Motors is not before you. Why are they raising that issue? It has absolutely nothing at all to do with this. And what they're claiming was that at the first planning board meeting, June 15, 2020, the application of my client, Bar Veloci, was for a special use permit. And the additional presented to the planning board shows the request was for a change of use of the upper level or an additional use, not to change the use of the building. They're trying to complicate the whole thing by making a claim to you that our attempt was to alter the entire building. That was never the intent. On the upper level of the building, we proposed a change of use. That was from the showroom to a food and beverage establishment, and that was where the showroom was. The minute shows that the applicants was presenting to change the use of the upper level, not of the entire building. And now they're trying to close down Narrowsburg Motors after 72 years of operation. Their second reason they claim is about the rooftop, and that we're somehow that we're improperly using the rooftop. We are not using the rooftop. The rooftop was not part of the CO. And a certificate of occupancy has been issued. And that's not what is before you tonight. The CEO says that we can first floor renovation from a showroom office to an eating and drinking establishment and roof replacement. The CO is valid, it's been issued, we can operate under, we are operating under it, and it has absolutely nothing to do with what's before you. Their third invalid reason is about the toilets. The granting of the building permit was to cure the problem of having additional toilets. That's all. The building permit application was not accompanied by construction drawings. There's no issue before you about construction drawings. To bring in about construction drawings, and Mr. Woods is here, the architect, whose signature is now being claimed to be valid or invalid, and bring up all these issues. What do these issues have to do with 3 bathrooms? What do they have to do with the operation of businesses in this town? All the other issues addressed by the Whitens were issues that were directed to the special use permit that should have been raised back in 2020. Then they have this reason number 4. The applicant is applying for a building permit. We consulted Tusten Water and Sewer Department Head David Bunce. He advised that the existing pump station is anticipated to be more than adequate for the projected flow. Tusten Water and Sewer met us on site, met the client, and inspected the station. And once again, these issues are not the question that is before you. In regard to number 5, the parking lot they talk about. Once again, that's an issue that should have been raised. If it was taken care of by the planning board back in 2020. The parking lot has not been enlarged. The only work done was maintenance of the existing parking lot. Some debris had fallen and touched the widened fence and was removed earlier this year. The previous existing runoff patterns have not changed, nor has the height of the parking lot changed. We have not installed a retaining wall. We have not expanded the parking lot. We have not created a steep slope condition. The hill in the parking lot is on a pre-existing condition. Once again, they're trying to argue issues like parking, etc., which are not before you. Number 6, the junkyard. There's no junkyard. There was construction materials in the parking lot area in preparation for construction work, which we have applied for permits for. Once again, they're attempting to confuse the simple issue of a building permit. The plywood referred to as retaining wall, is there solely as an extra temporary measure of prevention in order to contain any random building materials from rolling onto the neighbor's property. Number 8, existing restrooms are above the sewer main on the Bridge Street, as are in many businesses in downtown business district. The town utilizes pump stations from basements or lower levels throughout the business district. Many properties have 2nd or 3rd floors, which utilizes existing stations, and this building is no different. The suggestion of the Widens is their suggestion would have been an impractical solution. Number 9, there is no pre-existing staircase that is not accessible to the. There is a pre-existing staircase, but it's not accessible to the public. The staircase is located behind the bar and it's secured and locked at all times and not in service. And number 10, to do what they've done to Mr. Woods, he's here and I'll let him talk for himself. Let me just say this, back to why we're here, okay? We're here for an appeal concerning the simple building permit of these 3 bathrooms, not for everything else that they want to try to confuse and bring before you. Thank you.
Okay, we'll open up the public comment now. We have a list, an initial list. And Mr. Richard Crandall will be the first speaker.
Yeah.
If anyone else wishes to speak that did not sign in, there is a sign up sheet over there. So you're aware.
Make some more orderly.
Good evening.
Just one moment, Mr. President. I'm gonna ask, because of the volume of people that are looking to address the board tonight.
Yes,
To please reserve your comments to about 3 minutes, please.
of course.
And also direct all your comments to the board and not to the audience. Thank you.
My name is Richard Grant. I'm past supervisor of this township, past town justice, past chairman of the planning board, past chairman of the assessment board of review. I've lived here for my 83 years. I thank the Wydens for what they've done to the school. It was a big thing. And I agree with them that we should all be treated equally under the law. I was on the planning board when we created zoning, and a lot of people were afraid of zoning for what's happening tonight. There's the spirit of the law and there's a letter of the law. And it is up to you as board members to be the mitigator between the spirit and the letter. Everybody has their own viewpoint and you're the arbitrator. You can't correct a situation without a building permit. It's a catch-22. You can't get the building permit because it's an existing violation. The existing violation is a use that's been there for a long period of time. When I used to interview people for board membership, I would say to them, remember always, it's common sense. And that's what I would remind you tonight. Use your good judgment. Thank you for your service. You're in a very difficult position.
Thank you, sir. The next name I can't hardly read. It looks like Bonnie or Ronnie. Starts with a T or a C.
Number 12.
Number 2.
No. Number 12.
And I'm gonna move on to Joe and Santos.
No.
Hi, my name is Joan Canto. I have few businesses in the area.
Bring the microphone closer to you, please.
The question I think most of us have here is why this is continuing. We understand there were some issues with the building. And they were brought to the attention of the owner and he's rectifying them. But this continually harassing them and causing the business not to open, jobs to be lost. Frederick came to this town to open up something wonderful. He brought a team of people here to be employed, to bring people to the town. That's what we're all about, and having a town that flourishes. Ironically, 8 years ago, the Bidens were heroes to this town. They helped purchase that building. And from hero to zero, in my opinion. What if they did this to they think they're protecting the town? From what? From what? They need to get busy on their own, worry about their own business as opposed to going after everyone else's business. There's a lot of businesses here, there's a lot of people wanting to come here. But with this harassment over one person, I mean, to give a list like that, to go back to 1986 to find a signature that didn't match from a signature from 2023. I have to say, something is not right. I want to know what the end result is. If they can do it to them, they can do it to anybody else. Somebody puts a flagpole in front of their house and now they'll make a big deal of it. They don't want that flagpole. There's a lot of things in this town. There's people who have garbage in front of their home. Talking about a garbage junkyard. There's a lot of homes that have junkyards right in front of their lawn. But we have to respect, we have to understand, and if certain things were not done correctly, I am sure Frederick will go and take care of it and handle the situation and let's move on. People have lost their jobs. People have not, the business has, we're losing income, tax income for the town. This is going on too long. I think there's gotta, I want to know what the end result is. Do they want them to move? Do they want to set them to sell the building to them? I don't understand why they are continually going after these people and their reputation. Going after Carl, going after Frederick. It's just to the point that it's almost, it's like, it's not right, it's not fair, it's almost a vendetta or sour grapes. I believe when they purchased the union, they had to do a lot of things that the town wanted them to do. And I am sure it was heartache for them. They spent a lot of money, did a lot to that building, it looks beautiful. But
Please wrap it up.
you cannot keep going after somebody for every little thing. It's getting to the point that who's gonna be next? Thank you.
Fifty and last,
I'll pass, I'll
Okay.
about it.
okay, Carl Wasner.
Hello, my name is Carl. Just want to say thank you for all the support that we're receiving from the community. We really appreciate that. It means a lot to us all. And I just want to take a minute to just try to, bring this back to the purpose, which was that, this current complaint goes back to the plumbing permits. And I just wanted to reiterate, so many of these complaints and all this, documentation really is totally unrelated to the permits at hand. And it just seems like a reaching at straws, a lot of throwing things at the wall and seeing what sticks. And it really just doesn't add up to a whole lot of sense when we look at it. We've been looking at it a lot. And I just wanted to point out that obvious statement and say thank you so much, because at the end of the day, even like trying to get rid of Narrowsburg Motors because of some kind of a C of O issue, if it could happen to them, then any business in the whole town could, have their C of O questioned. Because, a lot of these businesses have been here for tens of years, 20 years, 30 years, 40 years or more. And a lot of these buildings were built in the 1800s. They're not all brand new strip malls that, a lot of these zoning codes oftentimes are tailored to. There's a lot of existing building, a lot of existing infrastructure. Our town plumbing system is not the best. It's not, pump stations, not the best thing to do. Would we do it again? Hopefully not, but that's what we have to work with. So I just wanted to say thank you to the board. Thank you for all the support and really appreciate careful consideration of these issues with an eye to the businesses, many businesses in town that really want to try to prosper and survive. Thank you.
Thank you.
Good evening. Mine is just a question. Has anyone provided a statement, if it's required, made by a professional engineer that the roof is strong enough to hold the weight of people? I ask this because of, I don't know, within the last 2 months or so, I suppose, I read an article in the paper about a fraternity house. The brothers had a party. They all ended up on the roof. The roof collapsed. Many of them were seriously injured. And in the article, the reporter said roofs are not subject to a requirement that the same requirements as floors on which people will be gathering. So I would like to know if the roof of this building is strong enough to support people using what the owners have built. Thank you.
Looks like the last name is Wood.
I'm Charles Woods, a mysterious architect that appears to be and not exist and to be in different offices and to different signatures. And I just would like to preface a short thing about my history, very short.
Very brief, sir.
I know, but I think it's important. In the fall, I will be registered in Pennsylvania for 30 years. In New York, it's about 10, I think now. I've never sued anyone or been sued. I've never had a structural failure. I'm an author of 7 architecture books. I've been in 50 magazines, won numerous design awards. World famous architects have commented on my books. So it doesn't mean somebody can't criticize me on anything. I have never, those signatures are mine. Carl has never put himself out as an architect. It would be illegal for him and me. And just recently, someone complained about him being in an ad. That's true. He's been in many ads. I made the mistake of saying junior partner, which is legal in Pennsylvania, but not in New York. And the New York investigator called me and we settled it. It was just a phone call, you know? And so they want me to get my license as Charles Gregory Woods architect in New York. In Pennsylvania, I have 2 licenses, one saying an associates, and they just asked me to get mine, another one saying I'm an associates, that's it. Now, in terms of all these different names and everything, none of that is true. There's a letter or bill or something like that we sent out. We didn't have our regular stationery. I had used my older stationery before I was registered called Natural Architecture. Everything else, there's no drawings with different names and all this. And, you know, Brendan just recently implied that my office isn't my office because it's 61 Commercial Street and my stationery and licenses say 65. He's correct. After I'd already been there 20 years, they changed the address of that building because the people in the barn next door, I think, were gonna start getting mail there. And I said, what am I gonna do? I have 20 years of publicity on this. And the mail people told me, your mail is not being changed. There's 4 buildings on the whole freaking street. So anyways, I care about architecture. To become a registered architect, again, this doesn't mean that I can't do something wrong. I had to take a test that is 32 and a half hours, 9 parts. One test, 12 hours straight with no breaks. You can go to the bathroom where people were crying and eat while you're drawing. And I'm proud that I'm an architect and I take it very seriously. And I don't dislike Brendan or his wife. I pray for them. I mean, maybe I was tougher at one time, but at this point, my testosterone's been gone for 20 years. I just love everybody. We just don't get along. Whatever, if there's any other questions you have directly on this stuff, I'll be happy. In terms of the roof, we had an engineer engineer it. And when Biden complained about me 2 years ago and they researched everything and they said, no, you haven't done anything wrong. We tried to re-engineer everything and not correct everything, make sure every single thing could be safe, including, she had a valid point. I wanted to limit the amount of people that could be up there dancing, because yes, that's a tricky thing. And so we cut it way back. It's way beyond the strength it needs to be. And we have a sign saying no more than 100 people or 75 people or something like that. So anyways, I just, I've been starting to feel like I don't exist. This keeps coming out that this isn't my office, this isn't my signatures. I am a registered architect in New York.
Martin Hagan.
Hi, my name is Martin Higgins, and I'm co-owner of Two Queens Coffee here in town. I'm former president of the Narrowsburg Chamber of Commerce, and I just have to start by saying that I do appreciate the Widens. I've known the Widens for a long time. I've worked with them since they purchased the building in many constructive ways. I know their heart's in the right place and they want to do the right thing, and they do care about this town. But my concern is that now we've gotten to a place where we have a business being held hostage and being harassed constantly to make an example of the things that aren't always getting done correct. I don't disagree that some things don't get done correctly, but this is a small town with a lot of volunteers doing the work that you guys are doing. And we can't expect it to be handled like the way it might be in New York City or in Westchester or a bigger place where you have large staffs and large salaries and larger tax bases. So I think we do have to have an understanding of one another and our businesses and our intents. And I do think that there needs to be maybe arbitration at this point, because it doesn't seem like there's a way to move forward through the regular processes. It's just going back and forth forever, 3 years now over every little thing. And I just know that reading through the town code, there is something in there about arbitration. And I wonder if this is the point that gets talked about. Because it doesn't seem like this is really gonna get better. So, for your consideration. Thank you for hearing.
Thank you, sir. Charles Wilkin?
Hi there, I'm Charles Wilkin. I'm the other half of Two Queens. The Wyans talk a lot about fairness, but what they're doing is truly unfair. And I think, they're trying to save the town from you not doing your job, which is just, I think, offensive, honestly, because you're working really hard to try and solve the problems of this really old town. And I think the sad part of this whole situation is they're just using Bartolocci and now Narrowsburg Motors as a scapegoat to figure out and solve whatever problems they're trying to get you to resolve. They should have gone to you first, I think, in my opinion, and worked it out with you all first, instead of forcing this issue on now two businesses. So my question and my concern tonight is, how does this end? Because when I read the code, there's, anybody in this town can file a complaint. There's no limit on that. So what's to stop them from just continuing on this path, or anybody in this room to file a complaint against any business? I agree with Martin, maybe arbitration is the way to go. But, I'm hoping that you guys will do the right thing and see that this is purely harassment. This is what they're doing. And it's totally not okay. And it needs to stop. Thank you so much.
Okay, the next person, and forgive me with the last name, Sarah Van.
No.
No? Okay. Bonnie Orlock or Carlock? Okay, she's out. Barissa Thompson. Or Larissa. No? Scott Carlson. Oh, no.
No.
No? Peggy Kraus. Rachel Jones. And I can't make out the last name. Looks like Kai.
Hi.
Step up to the podium, sir.
My name is Kai Brasil. I'm 21 and I want to be an entrepreneur and start my own business. And for me and people my age, seeing somebody, a business entity being harassed to this degree is terrifying. I mean, for me, I wouldn't know what to do. And these Bartolocci guys, they're great. Having to deal with this, being patient. And I just wanted to let you guys know how it looks to me as a 21-year-old entrepreneur trying to start a business. Just wanted to bring attention to that.
You are? Yes, please.
But I'm not gonna say nothing, I'm just putting it in a war stand, I've been through a lot.
Okay, thank you.
I think it's it.
Okay, Joe Carreri.
All right, what you do.
I'm Joe Carreri. I don't think anyone's trying to shut down Narrowsburg Motors or Bob Pelosi. I think all they want is for them to go by what was approved. I was on the planning board. I know it was approved. Narrowsburg Motors to operate on a lower level for their repair shop. The lower level, the back, was supposed to be a parking lot for either 14 or 16 parking spaces. The right side of the building, there was supposed to be 2 handicap spots. This is all on the drawings. One of the handicap spots was eliminated for the steps that go up to the roof. That was not approved by the board. September of 2021, they came to us again. And we asked for engineer's approval, an engineer's stamp that the roof was capable of holding what they have. What they showed us was an architect stamp. That's not the same as an engineer stamp. I've been in construction for 40 years, commercial, and I know the difference. So the roof was never approved, and now I hear they're going for a permit for the bathrooms. One of the bathrooms is on the roof. Well, if they don't plan on using a roof, what do they need a bathroom on a roof for? If it's not approved. So a lot of stuff was changed from what we approved. We gave them a chance to come back to us in October of 2021. They never showed up, but were issued a CFO back then. That's all I gotta say.
Thank you. Okay, so we'll go to anybody on Zoom that wants to make any comments?
Yeah, hi, this is Ned Lang. I'd like to make a comment.
Repeat your name again, sir?
Ned Lang, you know me very well, my friend.
Yes, sir. Yes, now I got it.
So listen, I've been listening to what's going on there, and I've been part and parcel to this whole drama that the Widens have created. As you know, I own the Narrowsburg Inn next door, and Frederick and his group have come to me and released the inn. Let me back up a little bit more. I served for 9 years on the Tusten zoning board. And during that time, I've never, ever seen any type of action come before the zoning board with these type of issues. The zoning board, you know, you're not trained. I'm a licensed master plumber. I know about plumbing. I know about the construction code, but the zoning board folks are not versed in what's allowed and not allowed under the building code. Okay. What the zoning board is there for is to deal with use issues, setback issues, not plumbing issues, not pump station issues, not the liquor license issues. I mean, in my bar, I've got stairs going upstairs to rooms. I got stairs going downstairs to the basement. It's all pure, just drama. Okay, what the Widens are doing is wrong. And what is really egregious here is that the issues that they're raising are so outlandish. You know, these issues should be raised before the code enforcement officer. And apparently the code enforcement officer is not giving them the answers or the direction that they want. And if they wanted to appeal that, they should go to Albany and appeal to the code enforcement officer in Albany, not before the Tusten zoning board. The Tusten zoning board, you don't know about plumbing issues. You don't know about issues inside the building, and nor are you supposed to know those issues. These are not zoning board issues. This is an attempted end around the code enforcement officer and his office of the town of Tusten and bringing this issue before the Tusten zoning board. This is wrong. It's egregious. And the car repair sales business, you know, just because they wanted to expand their business and move it up by my business up on 97, that's their business. But they have a right to, after how many years, 60 years, 70 years, to continue their operation. And the Widens, how dare you try to stop them from operating a continued business for so long? Shame on you. You're supposed to be the Narrowsburg Union. You do anything but bring union to this town and this community. You were wrong. And how about the Widens operating the U-Haul business? Did they have a permit for that? Did they come before the zoning board or the planning board to rent U-Hauls out and equipment out? I doubt it very much because I haven't seen it. So what the Widens are doing is disgraceful, it's egregious, and it's wrong. And I implore the Tusten zoning board to reject this egregious, wrongful, and outlandish attempt to circumvent the code enforcement officer's authority in the town of Tusten and go around his authority and come before the zoning board because they're not getting the answers they want before the Tusten code enforcement officer. They're wrong. And I would tell Frederick and anybody that has to withstand this kind of punishment, this unlawful, frivolous, and egregious lawsuits to try to stop them, to sue the hell out of them, because that's exactly what they deserve, because they're causing a lot of damage, not just to Frederick and his business, to my business, that anybody, that young man who just spoke a few minutes ago, what young entrepreneur wants to come to our town with folks like this who are just so brazen just to throw around the muscles because they got a few dollars? That is wrong. And the Widens should be ashamed of themselves. And I'm telling you right now, the zoning board should throw this appeal out the window. There is no legal ground for the zoning board to address plumbing and electrical and liquor authority issues within a building. You are there for another reason, and you do your job well. And I thank you for your time, and I appreciate it. And the Widens should be ashamed of themselves.
Anybody else?
Hi, my name is Jess Lewis. I'm one of the founders of an online community group hosted by Instagram called Sullivan County Mamas. Along the same vein that I think his name was Ned, or who was just speaking about all of the small businesses that the union is hosting. How many small businesses? I'm not sure of the exact number. But I know that there is obviously an inherent conflict of interest with union actively harassing small businesses while at the same time hosting small businesses. I know that within the community, there's concern and moral conflict about supporting an entity like union that hosts so many small businesses. It's almost like they're hiding behind the fact that they host small businesses while also harassing small businesses that aren't in the union. Just a conversation that's happening in the community, definitely conflict of interest, I feel like, happening there, and kind of, a byproduct of what they're doing is putting the small businesses that they're hosting at risk of losing customers, which I'm sure they already are.
Anybody else in Zoom? One second. You are, ma'am?
My name is Star Hesse. I've been listening to a lot of the conversations this evening, and I would like to just mention that I think one of the first things that Mr. Gailey said was that in the law, if there's a violation of any sort in a building, no permits, special or otherwise, should be issued until that violation is corrected. Of the conversations I've heard this evening, there have been many violations presented to the board and to other people by the Widens that have not been addressed and haven't been corrected. So all this palaver about how are they making bathrooms, the whole thing about getting a permit for other businesses, it's not about the bathrooms or any one thing. It says in the law, if I understood correctly, if there's any violation in a building or property that's asking for a permit or a special use permit, that permit may not be issued until and unless that violation was corrected. And as far as the zoning board not being aware of that kind of information, how can you possibly legally and ethically issue a permit if you don't know the rules about issuing permits. And I think that's what I heard you say, that you're not aware of that. That wasn't something that you knew about. So you were just gonna go ahead and issue this until, I don't know what, something else is proved. I think the Widens have made a very cogent statement. It's been presented in the proper fashion, and what they have said proves there are violations that were not addressed at the time when they occurred and have continued to not be addressed. And now it's just going to be completely brushed over, and absolutely that's going to be done now because some people have invested money and we don't want to lose the money for them. The Widens are not looking to put anybody out of business. They're not being two-faced about having small businesses in their establishment. Their small businesses and support are legal. They're following the rules. And that's what should happen with Barbelochi. They need to follow the rules, and you need to enforce the town codes and other rules before you issue any kind of permit. Thank you.
Anybody else on Zoom?
Everybody else has their hand raised.
Last call in house. Nobody else? Going once?
Because of that roof thing being so important, I just want to ensure everybody, we do have stamped engineering plans. And it's normal for architects to stamp something that's already been checked by an engineer, and I'll be happy to show them to anybody. Just because I'm interrupting, but because I thought that was so important for people to know. Sorry.
So no other comments?
Yeah, I'd like to,
You want to?
yes,
Back up? Okay, go ahead.
as long as everybody's done in the public.
Yeah, it's confused now.
I'd just like to take 2 or 3 minutes to address some of the comments that were made tonight. First of all, the Winans are not the reason that Barbelochi is not open. The bar has a certificate of occupancy to use 980 square feet of that street level.
No, not 1,000, sure.
Well, they have an approval, planning board approval to use it for 980 square feet. And then a CO to use it for a larger area, which was not approved by the planning board. So the Winans are not preventing the opening of Barbelochi at all, in any respect. Secondly, the Winans are not seeking to close down Narrowsburg Motors. The planning board minutes state that the sales portion of that business will be moved to a lot on Route 97 near the Town Highway Garage. And the minutes have to say that because the bar restaurant displaced the sales from the street level of the building. And it's unlawful, as the planning board knew, for those sales to be moved down to the lower level because that's moving a non-conforming use. It's prohibited by the zoning code. So it's not the Widens who are seeking to close down Narrowsburg Motors. They're not seeking to do that at all. That's not the point of this. It's the planning board. And Mrs. Johnson, the owner of Narrowsburg Motors, was on the planning board. She didn't vote on those, but she's at all the meetings. She knows what happened. She knows what the minutes say. So they can't come back now and say, oh, no, the Widens are trying to close us down. Secondly, Mr. David Hall stated that the Widens had started an Article 78 proceeding against the restaurant. That's not the case. It's just the opposite. As this board knows, we appealed the issuance of the CO to this board. The board initially ruled that our appeal was untimely. Then the board reversed itself and said that it was timely. It was Barbelochi that sued the ZBA and the Widens on that reversal to say that the appeal was timely. So the lawsuit was by Barbelochi, not by the Widens. How do the bathrooms relate to the 10 reasons that the building permit is unlawful? Because there are at least 10 reasons that we say that the issuance of that building permit is unlawful, and we detail it in our appeal. 5 of those reasons relate directly to the zoning code, have nothing to do with the state building code or the state plumbing codes. The comments that this board shouldn't even be hearing it for that reason are simply wrong. It's true that violation of the state building code or the town building code or the state plumbing code is a reason. It's a requirement that the building permit not be issued, but that's not the only reason. 5 of those reasons deal directly with the town zoning code. The comment was made also that this appeal relates to the special use permit that was granted for the restaurant almost 3 years ago. Not at all, not in any respect at all. These deal strictly with the bathrooms, has nothing to do with the approval, has nothing to do with the CO that was issued for the restaurant. The claim was made that the parking lot should have been addressed by the Widens back when the planning board granted the approval. There was nothing to address then. There was the site plan doesn't show any enlargement of the parking lot. It was, and even though you can't enlarge a parking lot or change your site at all without site plan approval, the property owner did that. So that's the violation. There was nothing the Widens could address back then. They can only address it now. It's the same with the bathrooms. The claim was made that the bathrooms relate to the special permit approval. Not at all. Those bathrooms weren't shown on any site plan approved by the planning board. So there's nothing that could have been addressed back then. The bathrooms were only issued the building permit and became an issue only in February when that building permit was issued. The comment was made that building permits can cure a violation. Sometimes that is the case. In this case, though, the issues of the building permits cause the zoning violations. With respect to the junkyard and the debris, the comment was made about there's a lot of debris around the town, and people should either deal with that or maybe deal directly with their neighbors if they have the debris on their property. Well, the Widens tried 3 times, twice in writing, asking the owner of the property to remove that debris, never received any response. The comment by Mr. Woods that in Pennsylvania, it's legal to call non-architecture partners. That's I don't believe that's correct. We have it in our appeal also on those types of requirements. And the thought and the idea that the Widens should have first come to the ZBA to try to work things out, which was one of the later comments that were made. There's no opportunity to do that. We can't work things out with the ZBA. The only thing we're allowed to do is to appeal the issues of the building permit to the ZBA. That's what the zoning code says. That's what the state law says. That's what we did. Lastly, I just want to make a submission to the board, and this is nothing new. It's just an illustration of what was approved by the planning board. It's in our appeal, but it's a pictorial that shows what was approved. Thank you. I'm nothing.
Mr. David, oh?
I don't intend to keep these good people here any longer, okay? And I think that we're just losing sight of again, what the initial is. Number one, we're not using the roof. We understand that before, even the CO was just for the use of the first floor, which is being used, which is open now. We're not using the roof. We understand we have to go back to the planning board and clarify certain issues to use the roof. In regard to the violations that are claimed exist and that that this permit should not be issued is, number one, we don't believe that there are any significant violations that occur. If any building in Narrowsburg wanted to fix a bathroom and go out and get a building permit and the CO, your code enforcement officer, granted it, if anybody wants to take a microscope and look into what else in that building maybe should be done, would create some unbelievable situation. Okay, there are no outstanding important violations that exist that should prevent this permit for these bathrooms who have been issued by the CO. Your CO knows what he's doing. He has the experience. He issued the building permit, and that's all we're here about. Thank you.
Okay, so with that being said, I'll make a motion to close the public hearing. Anybody want to second it? Second, all in favor?
Aye.
Aye. Okay, the unanimous vote. Motion carries. The public hearing is closed. So now we'll open the regular hearing with the pledge of allegiance. Pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice. Please.
Yeah. Yeah.
Okay, folks, so the last month's minutes, did the board get all of the minutes I forwarded to you? Anybody have any changes or additions?
No,
No? So I'll make a motion to accept the minutes. Anybody second?
I'll second them.
Okay, all in favor?
Aye.
Aye. Aye. Okay, motion carries. The minutes are accepted. Old business. Anybody here for John Glover? Sir, step up, please. That's your son, right?
Yeah, I think he's on Zoom.
Is he?
Yes, he is.
Okay, then you can sit down.
Hey, John, you're muted.
Hey, guys. Hi. Thank you again to the board and everyone else.
Hello. I received your email late.
Yep.
And it said that you wish to withdraw your application.
Yeah, I guess what I wanted to, and I apologize for not being at the last meeting. I feel like I should have been there. Especially in light of hearing the last kind of hour or so. You know, the request I was making was actually to sort of prevent further development. It was a very small change. That being said, I completely understand where the board was coming from, and I think I would do things differently if I could resubmit. I think getting, you know, all of my neighbors are very supportive of this because it would prevent anyone from sort of building unnecessary items along the side of the road that would not require permits. So it would just make the road look worse. And it protects the land. That being said, there are rules, and I don't want to put anyone in a position where they feel like they are making an exception. I just want to protect this land. This is basically my front yard. So I think it was, you know, the intention of this was just to say, maybe I should rescind my request, prepare potentially a letter signed by all the neighbors, and then resubmit the application to the board at a later date. As long as you guys are okay with that, I think you don't have to officially reject me or anything like that. I'll prepare everything and come back at a better time.
And you fully understood our suggestion to you concerning your application, did you?
I don't know. What I was told was that the request was for me to give up my riverfront. If that is the case, I think what I would say is kind of twofold. One is I've been coming to the Delaware River since I was 3 years old in 1985. I have 4 small children. Giving up my riverfront, buying in Narrowsburg to be on the river, you're not going to give up your riverfront. But two, and I think this is an important thing just for the zoning committee, to go from a riverfront property to a non-riverfront property would significantly change the tax liability, right? If I don't have a riverfront piece of property, I'm not taxed as having waterfront, and that's just less revenue for the town. And I don't know why anyone would, for a technicality, which is what this kind of seems like, I don't know why the town would want to reduce their income when budgets are constrained the way they are. So
Did you understand that we suggested that you employ an easement so you would still have access to the river?
Yeah, still having access means I'm sharing it with whoever owns that property, and they have their own riverfront. So that was the issue. It would also, though, the second point still stands. It would go from being riverfront property to not riverfront. And there would be money that I would end up paying less in taxes. And so I thought it was actually a pretty ingenious idea. And frankly, if it was a situation where it was that easy, or if maybe I didn't have the same emotional connection to the riverfront that I do, I would be fine with it. That being said, the request I'm making is actually quite small. I'm not neither here nor there. That's why I'm willing to rescind my request. I did not think this was a big deal. This is not, the Bar Veloce situation where everyone's extremely passionate, myself included. This was very simply, look, this property owns part of my front yard and it doesn't make any sense. I don't want them building a shed or something like that just because they can. And so I wanted to recut the property lines. It could have been a financial transaction, so I could have paid them for this lot of land. It wouldn't have been a very expensive one, but call it $5,000 or $10,000. I just want to make it unbuildable. It's just the way it should be. Now, it's also land where the city puts up, or the town puts up street signs and things like that. That's all fine. What I'm really preventing is kind of junk sheds, things like that. It's not enough space to build anything that would require a permit, and it is a small town and people kind of just build what they want a lot of times. And frankly, I know that if I recut the property line, it would protect against that.
Okay, so at this time, you're going to withdraw your application and come back to us at a future date?
Yep.
Yes?
Yep, that's right.
Okay, so I'll make a motion to accept that withdrawal from Mr. Glover, and anybody want to second that? I'll second. Okay, all in favor?
Aye.
Aye. Okay, it's withdrawn, and we'll see you in the future.
He said thank you.
Okay.
I just got waiting, sorry.
Okay, now going on to the Wyden application concerning the building permit for 3 water closets at 174 Bridge Street that was issued back in February. After listening to all of the public comment, and it's pretty evident that there's a lot of emotion involved with this. So, to cut to the chase, I'm going to make a motion to dismiss the application in its entirety. And for the reason is that I don't believe that the Wydens have standing in this, all right? And the reason being is that in order to have standing as a third party in this situation, they would have to show how their property value has been diminished or affected negatively. All right, they have not done that one iota. Okay, either in their submissions or in verbally, they have not shown how three water closets in an existing structure is affecting their property value in this situation. All right. So with that being said, Ken, you want to read that resolution?
Yes, you want me to?
Go ahead, please.
Before a second is made, as a matter of law.
No, I object to this. The meeting is, you're running your meeting. We cannot interrupt it, and I have to interrupt.
We
No.
are the applicant.
You
We
have
are
no
allowed-
right to interrupt their meeting.
I
The
understand.
public hearing is over.
We're not the member of the public, general public.
You're
We're the
interrupting the
applicant.
meeting.
Sir,
As a matter of law,
you made your statement and you closed, okay?
but this is brand new. This
No,
is brand new.
It's not brand new.
Sure it is.
This is, we're giving you our judgment on this, all right?
But I would just want to advise the board.
You don't need to advise the board. You're not their attorney.
Please stop
Their
interrupting me.
attorney is there.
Please stop interrupting.
Their attorney is there. He can advise the board. Let the board decide what they want without any more input.
As a
Please,
matter of
Mr.
law,
Gailey, Mr.
there
Gailey,
is no requirement to show monetary damages to have standing.
Mr. Gailey. Ken, go ahead, please.
All right, so because Neil had reached this, come to this sense of it, I had prepared a resolution and provided to him. And essentially, the resolution reads, whereas Brandon and Kathleen Wyden, and we're going to be referring to them as the applicants through the rest of this, have filed an application to the Town of Tusten Zoning Board of Appeals, and now it's going to just be referenced as the ZBA, dated March 30, 2023, appealing the quote issuance of building permit dated 2/2/23 to 174 Bridge Street, Narrowsburg, New York 12764, close quote, which application was supplemented by additional submissions, each dated May 8, 2023. And whereas at its regularly scheduled meeting on May 8, 2023, the ZBA heard a verbal presentation by J. Benjamin Gailey, ESQ of J&G Law LLP, on behalf of the applicants in support of the appeal. And whereas following the aforesaid presentation by the applicant's counsel, the ZBA heard a verbal presentation made by Michael Davidoff, ESQ of Drew Davidoff and Edwards Law Offices LLP, on behalf of Upper Delaware Hospitality Corp. And we're going to refer to them hereafter as the permittee, owner of the premises located at 174 Bridge Street in the hamlet of Narrowsburg, Town of Tusten. We're going to refer to that as the premises hereafter, to which the subject building permit, which we're going to refer to as the permit, was issued, who informed the ZBA that the applicants had not informed the permittee of the appeal and had not served the permittee copies of the papers upon which the appeal was brought, and by reason thereof, he was not prepared at that time to respond to the appeal. And whereas the applicant's counsel stated that he would provide copies of the documents submitted to the ZBA on the appeal, and the ZBA scheduled a public hearing to be held with respect to the appeal on June 12, 2023 at 7 p.m. in accordance with the requirements of the zoning law. And whereas on June 7, 2023, counsel for the permittee filed with the ZBA a written submission on behalf of the permittee in response and opposition to the appeal, and provided copies thereof to the applicant's counsel. And whereas the ZBA held a duly advertised and properly noticed public hearing on June 12, 2023, at which the ZBA heard presentations on behalf of the applicants and the permittee, as well as comments of all persons appearing at the public hearing who desired to be heard. And whereas at the regular meeting of the ZBA that followed the aforesaid public hearing, the ZBA took up consideration of the appeal. Now, therefore, be it resolved that the ZBA hereby makes the following findings and determinations. 1, the applicants have not established that they are aggrieved persons as is necessary to have sufficient standings for the ZBA to entertain the appeal on its merits. Subparagraph A, applicants allege in boldface on page 1 of their written submission to the ZBA dated March 30, 2023, that, quote, as an adjoining property owner of property which directly adjoins two lot lines of 174 Bridge Street, we are aggrieved by the issuance of the building permit, close quote. Subparagraph B, pursuant to town law, section 267-A, subdivision 4, an appeal from and reviewing any order, requirement, decision, interpretation, or determination made by an administrative official may be taken by any person aggrieved by it. Consistent with the foregoing, section 300-11.6, paragraph B of the Town of Tustin zoning law, which we'll hereinafter refer to as the zoning law, provides that an aggrieved person may take an appeal from an administrative act of the Town of Tustin's code enforcement officer. Subparagraph C, in section 300-11.2 of the zoning law entitled, quote, general procedures, close quote, reference is made to information being available from the New York State Department of State, Division of Local Government Services applicable to the ZBA. Accordingly, the ZBA has looked to the Division of Local Government Services for guidance, particularly a publication by it entitled, quote, Zoning Board of Appeals, published in 2005 and 2023. In addressing the question of who is a person aggrieved, it notes at page 22, citing a court decision in Eckerman v. Murdoch, 76 AD 927, Second Department, 1950, that nearby landowners may be, quote, persons aggrieved, close quote, from a decision concerning land not their own, where their property stood to be materially depreciated in value as a result of the challenged administrative action. Subparagraph D. It also notes at page 23 of the aforesaid publication, citing Village of Russell Gardens v. Board of Zoning and Appeals, 30 miscellaneous second 392, Supreme Court, Nassau County, 1961, that by analogy, in a case involving a variance, quote, even close proximity to the property involved was insufficient to make a person aggrieved unless there were some showing of detrimental effect on the property of those contesting a variance. Subparagraph E. The Division of Local Government Services sums up its guidance on this subject in the aforesaid publication at page 24 thereof, stating, as a general rule, quote, as a general rule, any person whose legal rights or interests or property would be detrimentally affected by an action taken by the building inspector or zoning enforcement officer is properly an aggrieved person, no matter how distant his or her property may be, as long as in the municipality affected. Subparagraph F. Similarly, in another publication of the Division of Local Government Services entitled, quote, Guidelines for Applicants to the Zoning Board of Appeals, and that's from 2023, at page 1, under the heading, Who may apply to the ZBA for relief? It states, quote, a person is aggrieved if his or her property value is affected negatively by the enforcement officer's action, close quote. Subparagraph G. On this appeal, there has been no showing whatsoever by the applicants that the value of their property will be materially depreciated, or that there will be some detrimental effect on their property, or that their legal rights or interests or property will be detrimentally affected by reason of any work done by the permittee under the permit. No evidence has been presented by the applicants in their written submission or in their presentations to the ZBA on May 8, 2023, and during the public hearing on June 12, 2023, to demonstrate that any work in furtherance of the permit will devalue the applicant's property, detrimentally affect the applicant's property or their legal rights or interests. The work contemplated by the permit is interior work that is not visible from the exterior of the premises and will not cause a change in the previously approved use of the premises. The only basis alleged for being, quote, aggrieved, close quote, is applicant's claim of being an adjoining property owner. Conclusory assertions of being aggrieved are not sufficient. Subparagraph G. The ZBA also notes as a separate and distinct matter, according to public records, of which the ZBA takes official notice pursuant to section 300-11.f, paragraph F of the zoning law, the applicants who have filed the appeal in their individual capacities are not actually the owners of what they identify on page 1 of their March 30, 2023 written submission as being, quote, property which directly adjoins two lot lines of 174 Bridge Street, close quote. According to the Town of Tusten tax map, the property that directly adjoins the premises on two sides is Town of Tusten tax map parcel 10-2-5.1. According to public records, the property was conveyed by the County of Sullivan Industrial Development Agency on February 1, 2023, the day before the permit was issued, to an entity named Indian Fields LLC. Accordingly, the applicants, despite asserting as their sole basis for being aggrieved that they are owners of identified property adjoining the premises, cannot be, quote, aggrieved persons, close quote, for that reason, as they are not owners of that adjoining property. Paragraph 2. By reason of the foregoing, the ZBA finds it unnecessary to consider and makes no determination with respect to the merit of any of the substantive arguments asserted by the applicants in support of the appeal. Given that at the threshold, there has been no basis presented upon which it may be concluded by the ZBA that the applicants are, quote, aggrieved, close quote, in the context of the New York State town law, the zoning law, and applicable legal precedent, the ZBA hereby denies and dismisses the appeal in its entirety by reason of the applicant's lack of standing as aggrieved persons. That's the total of the resolution.
So with that, I'll reiterate the motion to accept that resolution. Anybody want to second that? Anybody, all in favor? Anybody in favor? Rich?
I'm in favor, aye.
Right, aye. The vote is unanimous, the resolution's adopted. And the application is dismissed.
You don't have.
Do you have any more comments? Please, we're not done yet.
Yeah.
Whoa, what? Yeah. Well, we're not done, any more comments? No, okay, I'll make a motion to close the meeting, any second?
I'll second it.
Okay, all in favor? Aye. Okay, meeting's closed.